Someone make it make sense.
Probably a couple.
Greetings again, my squirrel friends. So this is going to be a really quick video, but I just wanted to update y'all. At the end of the last Bryan Kohberger video, I think I was pontificating, if you will, as to what I think would happen next. And I think what I said was something along the lines of, what I think will happen next is they will probably schedule a hearing so they can come in person and talk about scheduling a hearing, because that's what they usually do. So now we have a document that was just filed on June 13th, and it is addressing exactly that issue. So here we go. In the District Court of the 2nd Judicial District of the State of Idaho, in and for the County of Latah, State of Idaho versus Bryan C. Kohberger. Order setting hearing. A scheduling hearing is set for June 27th, 2024 at 10 o'clock a.m. Pacific time. This hearing will be open to the public and will be live streamed on the court's YouTube channel. Counsel shall be prepared to address scheduling dates, including a briefing schedule and oral argument dates for pretrial motions, including motions to suppress, motions to eliminate, and any motions challenging the death penalty, expert disclosure deadlines, a trial setting, deadlines for filing pretrial motions such as proposed jury instructions, juror questionnaires, witness lists, and exhibit lists, and sentencing disclosure deadlines. Okay, so this is a lot. I don't know that they'll be able to get all of this in, but let's just break this down. This is a lot. So a hearing for June 27th, 10 a.m. Pacific time. I live on the East Coast, so that is 1 o'clock my time. Funny thing, I will say, I learned this through following both Chad and Bryan Kohberger. Idaho has 2 different time zones. So if you're, for anything that's in Ada County, that's actually 2 hours earlier than my time on the East Coast. However, with Latah County, it's 3 hours. So I always have to remember that as I'm doing the math. So they're going to be arguing, so oral argument. He wants oral argument for all these pretrial motions. So let's name off the motions that are included in pretrial motions. So motions to suppress, motions to eliminate, and any motions challenging the death penalty. So those are all in one category, okay? Motions to suppress. So motions to suppress, which we see this here, that's typically going to be, it's just suppressing evidence. Oftentimes you're going to be dealing with constitutional violations, things of that nature, but it's just to suppress evidence. Now, motions in limine, it's similar, but it's a little bit broader. It can include evidence, but it can also include oral argument or like certain lines of questioning. It can exclude those from being able to come in at trial. That would be considered prejudicial to one side or another. In this case, it would be the defense filing motions in limine, but if it were a civil trial, like we saw in Daubert Hearings, either or both sides can be filing those in terms of the plaintiff and the defendant. So I should mention also for motions in limine, one exception here where it could maybe apply to the prosecution or the state filing a motion in limine. Motions in limine can also be used in a different manner to exclude certain expert testimony. That's another way it could be used, again, because it's to exclude anything, right? So again, it is a broader category, like we said. So it can be used to exclude certain expert testimony, in which case you might be looking at something like a Daubert hearing. I'm not going to go too much into that. If it comes up, we will discuss it more in depth. But essentially, a Daubert hearing would be a hearing where they need to weigh the credibility of what is essentially a new category of expert testimony. So it's we've seen expert voir dire oftentimes in trials, right? That's where they've got an expert witness and they're going to voir dire and just figure out what can they testify to, right? What are they experty enough at to testify to? If they've got this such and such qualifications, can they also testify to this other thing? And we did see that come up in the Murdoch trial with Mr. Phone Thrower. If you guys, I don't remember his name, but if you guys remember that, where what happened there was on rebuttal, the state's rebuttal, they entered him in as an expert witness for something related to cell phones. We covered all that in our deep dive, and the defense was, I don't know that they were really paying attention, I hate to say it, but they didn't object to him being qualified as an expert. And then he gets up there and goes and says a couple different things, and then eventually they hear that he tested this whole theory out by just chucking his cell phone around in his office. And then after that, Mr. Barber for the defense came in and said, hey now, like, I'm sorry, but this is not expert, blah, blah. And Judge Newman was like, sorry, you said it, you did not object to him being an expert. Done. I mean, they really fucked up with that one, because they just were not, they could have stopped it and they didn't, and it was too late, so anyway, but had they been paying attention, they probably would have objected to that, but that would have been for that one specific element of what his testimony is going to be. The difference to like an expert voir dire, with when we're talking about Daubert, is that it's for a whole new, like a category of science, okay, if you will. Let me use an example that's related to Idaho that didn't happen, okay? This is me using Idaho as an example, but this did not happen. Be loud and clear. This did not happen. But for anyone who was following what was going on with, quote unquote, the TikTok psychic related to Idaho, this was a TikToker who had made some wild claims. I'm not going to give any credence to any of this, but I'm just going to say she was making some wild claims about predictions with what was going on. I don't want to give too many details because, again, I don't want to give her any credibility here. But she was representing herself pro se in this lawsuit, and had it gotten past any of the early stages before it was just shut down, had there been anything there, especially maybe if she'd obtained counsel, could have been a little bit different, maybe. But this is a completely hypothetical, like in an alternate universe where you've got a TikTok psychic, okay? I'm going to use this as an example. Let's say that this TikToker or any other TikToker who claims to be a psychic wants to bring in an expert who can testify as to the validity of psychic claims in regards to predicting who committed murder, okay? That would be a great example of something that would necessitate a Daubert hearing, because that is not considered to be a verified or valid scientific finding, or it's considered to be pseudoscience at best, right? So they would need. So in other words, it's not just for the expert; it's for the entire category of what they claim to be an expert in. It's a whole new world, if you will, right? Like a whole new world from Aladdin. So hopefully that makes sense. Again, we can go more in depth into that if it does come up again, but that's just a brief, I say brief, sort of brief overview of a Daubert hearing, which could also result from a motion in limine if there's a motion in limine to exclude certain expert testimony, if that expert testimony is in that category of brand new science category that an expert's not testified to before in court, it's not been validated, verified, etc. I will also note that for any category in science at some point was new, right? Just like any piece of technology at some point is new, and it has to go through certain validating procedures, certain testing, has to have had enough there that it can be shown to be reliable. That's really what it comes down to. So everything that is now standard was at some point new, right? So first category, pretrial motions. We have three things. So those are the first two: motions to suppress, motions in limine, and then the third in this category of pretrial motions is any motions challenging the death penalty. Now, I am really excited to see what we will have coming up here. Like we've talked about both in this case and with Chad, we don't see this a lot. It's wild to me that there's these two cases out of Idaho that are both, we're getting to see how this is litigated, both pre-trial and then during trial, post-trial. Like right now with Chad, we're following the post-trial path with that and everything that's going on there. And actually, we do have a new filing for that as well. So that's all the first category of pretrial motions. All right, so then the next category after pretrial motions, we have expert disclosure deadlines. So they're going to be setting the deadlines for expert disclosure, which again, that makes sense too, especially if there's going to be anything regarding experts with these motions in limine. We'll find out. The next category, this is another big one, trial setting. Are they going to act? So it says a trial setting. I'm wondering if that's venue. That's kind of fun. It doesn't say setting a trial date. And it doesn't, and we do know that they had pushed out until at least August the whole change of venue, because that came up in one of the most recent documents I covered in the last video. So I don't know. It seems like if they're going to be discussing the venue in August, then this must be a trial date. But it says a trial setting, so that's an odd way of phrasing that. I'm really curious what judge means by that. Because normally you'd see setting a trial date, or it would say here, if it was in terms of the venue, be like, you know, the change of venue. But again, we know that was pushed out to August, so we'll see. We will find out on the 27th. All right, next up we have deadlines for filing pretrial materials, such as proposed jury instructions, juror questionnaires, witness lists, and exhibit lists. Okay, so deadlines for filing them. So they're just going to discuss those deadlines. And then the last one we have is sentencing disclosure deadlines. So as far as this goes, the sentencing disclosure deadlines, I would imagine this is related to like the pre-sentencing report, which, you know, we've talked about this again with other cases, including just recently Chad Daybell. That's what I would imagine that is related to here. But again, we'll find out more on the 27th. Dated this 13th day of June, 2024. Adobe is just on another level today. So signed by Judge. I love his signature, by the way. I know I've probably said that before, but that's about it here. So there we go. All right, so you guys know the deal. I will definitely be covering this hearing. The Karen Reed trial will probably still be going on. So it might be the type of thing where I record the hearing as it's happening and then cover it later on, but we shall see. So, so that's it for now. I shall also be posting another update for Chad here. So for anyone who's following both cases, definitely check that out. Also include in the description for this video a link to the Bryan Kohberger playlist. However, it should also pop up here at the end in case anyone is just now finding this and wants to see what else we've covered for Bryan Kohberger thus far. And until then, I'll see y'all next time. Thanks for being a squirrel. See you on the next one.